Greetings and welcome back to Criminal Evidence. We're starting with Chapter 13 here today. We're going to be talking about plain view, consent, vehicle, and administrative searches. And in actual reality, for the purposes of this video, we're not going to get so much into administrative searches. I've decided that this video is going to focus more on the plain view and the open fields doctrine, consent, and vehicle searches, some parts of vehicle searches. We're not going to go into detail in this video about like inventory searches. I really try to isolate the areas in this chapter where you will see them in your professional experience. You'll see administrative searches, you'll see inventory searches, but you'll do those more instinctively as like a second nature kind of thing. But plain view, consent, probable cause to search a vehicle. These are things that if you were to see them in real life, they're a flip of a coin. They're driven by instinct, but they can't be done by instinct. There has to be more than instinct to just do it. So that's why I isolate those, because I want to help you guys understand that these things require certain facts and circumstances, and you want to be able to point to those facts and circumstances instead of just saying, well, I had a hunch based upon my training. You want to be able to say, no, I saw this person walk across the street from the abandoned warehouse. It seemed like there was a lot of traffic going on in this abandoned warehouse, but it's an abandoned warehouse, so that looked kind of suspicious. Then I saw this person load up in the trunk of their car this big, bulky looking brown paper bag that was taped with duct tape. And then the person walked back and forth from the abandoned warehouse at least 10 or 15 different times with the same type of package, putting it in the trunk of their car. I want you to be able to say that and clearly articulate that, than just say, well, it was 2 o'clock at night and it was in a criminal area, so I just had this kind of hunch that was a crime going on. That's not what you want to say. Do you see the difference between the two? And that's what we're going to explore here today. And we're going to start right off with plain view and the open fields doctrine. Your book does a really good job with highlighting the first two elements of the plain view doctrine, and that is, one, the officer has to be in a place where they're legally allowed to be, and then two, the object has to be in a place where the officer can observe, or the law enforcement officer. And don't think this is limited to just police officers, because this could apply to an OSHA officer as well, believe it or not. As part of my job here at S&ME Inc. as a full-time in-house lawyer, we deal with OSHA citations, and I've argued before an OSHA citations on the fact that they didn't have probable cause because they were trying to search an area, a job site where we had some workers there, and they were trying to search it without a warrant. And OSHA, they're a federal agency. The Constitution applies to them. They had to have a warrant. So I had to go through the same analysis and show that they didn't have a warrant, so they had to go through some of these things. And I say that all to say that don't always just think it's a police officer. But anyways, first two elements. Number one, the officer has to be there. They have to be in a place where they're legally allowed to be. And they can legally be anywhere in public. If they're walking around on the sidewalk, they're walking a beat, they're driving around, it's in the public, anywhere that's not private. So that's the first element. The second element is you have to be able to observe what it is that could potentially be criminal evidence. The third element that your book shows on page 382 is interesting. It's a different way to word it than what I was taught. It says that there must be probable cause to seize what was observed. And to tell you the truth, that's not what the case law says. It doesn't say probable cause. I actually would say probable cause is a lower standard than what the United States Supreme Court has said. The United States Supreme Court said that the evidence has to be immediately apparent. Immediately apparent means that as soon as you look at it, it needs to be apparent on what it is. It needs to be apparent that that's a stolen TV. That's apparent that that's an illegally carried firearm. It has to be immediately apparent that that's drugs. That's what they're saying. So when you say probable cause, that does not mean immediately apparent. And there's a little bit. I have a little bit of an issue with that, but I know where it's going, and I want you to understand that what that really means is that has to be immediately apparent. And let's dive into that a little bit, because it's actually really not hard to solve elements 1 and 2 of the plain view doctrine. So you pull someone over, and we're going to go to the basic police officer situation here, but you pull someone over, You ask for the license and registration. So, you have probable cause to stop. Let's just assume that you can stop the vehicle. You're conducting a valid, speeding, stop. You're talking to the person, asking questions, and you kind of notice something in the back seat. Well, all right, you're allowed to notice that because you don't have to like hide your eyes. You can notice that, and you see something and you don't know what it is. Right away, plain view is not going to apply, because if you don't know what it is, then plain view doesn't apply. Now, let's flip it. What if you say you saw a gun in the back seat? Now, is a gun alone going to establish probable cause to search the car further? Is it going to allow you to grab that gun? Probably not, because unless there's some other facts, which I have not given to you in this hypothetical, the gun alone doesn't establish probable cause or plain view situation where you could then, if you essentially, when you establish plain view, means you have probable cause. And because you don't really know what that gun is, it's a gun, and there's danger to a gun, you need to ask the driver some questions. Now, let's really take it a next step further. Let's really go. What if you saw those same stacked up brown paper bags with the duct tape around them? You saw 10 or 15 of them, lined up on the back seat of the car. Is it immediately apparent? Man, that's tough. That could be laundry of all things. So again, it's not there. So you can see where, this number 3 element that is immediately apparent can become an issue, because it's so easy to want to say, the gun there, that, according to number 3 here, that's enough. That's probable cause, probably. At least the 15 brown paper bags, that's probable cause. But it needs to be immediately apparent on what it is. And that would essentially look like the criminality of the evidence is immediately apparent, meaning that you know what it is. Now, that means that if the officer has some subjective knowledge, something a little bit more, then that's okay, and he or she can use that to establish whether or not it's immediately apparent. So 15 bags. What if this car was identified prior, a prior situation to the officer, and the officer recognized the car, so he stopped the car based upon a prior identification. And based on that prior identification, based on that information, there was some other information saying that these brown paper bags would be found in the back seat of the car. So he gets there, and boom, there's the brown paper bags. Oh man, he's confirmed what it is. What if in that call it also says in those brown paper bags there's cocaine, right? Now, it's not immediately apparent that those bags are cocaine, but at this point in time, it's immediately apparent that that's in plain view, that this is the car. It's been confirmed. I've confirmed the inside of the contents of the car with these brown paper bags. I can now put my hands on it, open it up. Okay? That's enough. But understand, it needs to be immediately apparent. It's not that easy to just say, well, I knew. No. You need to be able to say it was immediately apparent what was in those bags. So that's the important part. Now let's talk about this legal premise thing. The idea of being where you're legally allowed to be. I'm going to merge this concept where the officer is legally allowed to be with this concept called the open fields doctrine. Now everybody should be familiar with the open fields doctrine, especially in West Virginia. If you look at page 386, you get a good example of it. You have the home, right? That's considered a place, people, places, and effects. Right, the Fourth Amendment protects those 3. So the home is a place. The people in it are protected by the Fourth Amendment. Outside of it is the curtilage. It's the immediate vicinity around it where the person has a reasonable expectation of privacy. It's not really protected so much by the person, place, or effects listing in the Fourth Amendment. It's protected by the concept of reasonable expectation of privacy, that person would expect to have privacy in the immediate vicinity around it. Now, let's talk about West Virginia specifically. Well, outside of the curtilage can still be part of the land that the homeowner owns. So that becomes an issue. All that is called open fields, okay? And technically, even if you have a no trespassing sign, that's not going to stop an officer from being able to go into that area, because in reality, they can still go in that area and obtain criminal evidence and hold it against you. And because you don't have a reasonable expectation of privacy in your open fields, it can be used against you, and it won't be suppressed because of the Fourth Amendment. Now, your question might be asking, why am I using the open fields doctrine as a way to talk about where police are legally allowed to be? Because of the fact that it kind of creates a curtilage for police officers as well. See, the curtilage extends the home. The open fields doctrine expands where officers are legally allowed to be. Everyone is aware that an officer is legally allowed to be, at the sheets, there on, in New Creek. Everybody knows that a police officer is allowed to be on Potomac State campus. Everybody knows that a police officer is allowed to be in these places. Everybody agrees that a police officer is not allowed to be in your home without a warrant. Everybody agrees on these things. They're black and white. But there are gray areas, and that's the only reason why we have this book, and that's the reason why people like me have a job. So in this gray area, we have to figure out whether the officer has a right to be there. And this open fields doctrine kind of adds some area there. It allows the officer to kind of come within the private property of someone else and get criminal information and actually use it against the person who's the homeowner inside, because there's no reasonable expectation of privacy. That's a very unique concept when it comes to that, because you still own it. It's still considered private property. And even if you have a no trespassing sign, the officers will still be able to use that to go on the property, get information, even though that no trespassing sign is there. And I have a wonderful example of this. I worked on a case that went on to appeal to the North Carolina Supreme Court of Appeals. I was about to say the Fourth Circuit Court of Appeals, but it actually didn't go that far. It went to the North Carolina Supreme Court. And the issue was that officers had been observing this house in a rural area of North Carolina, very similar to an area you would find in West Virginia. And they were investigating this house, and specifically they were investigating the electric usage of the house. The usage was so random, especially during times where it wasn't warmer outside. When it was colder inside, colder outside, the electricity usage would fly through the roof, but then it would flow back down as the weather would warm. And what the police gathered from this information, in comparison to other places like Colorado, they determined that this information was indicative of a marijuana growing operation. So no longer are we just like observing with binoculars here or flying over the top of a house, so long as we're within FAA regulations. We're now monitoring electronic usage. And the police officers use this electronic usage to get a warrant, and the magistrate issued a warrant. And you're like, well, okay, well, that problem solved. Problem is that the case law actually says that's not enough. Like, you can't just have electronic usage. It's not enough to raise probable cause to issue a warrant. So the warrant ended up getting suppressed. So now the government is left with the argument of, okay, well, our warrant was not good. The good faith exception didn't apply. We talked about these concepts earlier on. Good faith exception doesn't save the warrant. The officers should have known better. So therefore, the warrant's no good. Now we have to go and we have to figure out what exceptions do they have. And the officers relied on the open fields doctrine. Now, they said that when they went, so they actually, once they figured out the electronic usage, they got the warrant. They actually went on top, not on top. They actually went into the house and the open fields and the curtilage and all this other stuff based upon a defective warrant. So now they had to justify all of that activity. Now they could justify the open fields because that's okay. But if they only justified the open fields information, they would have never been able to justify the information that they got inside the home. So they actually had to not only go from the open fields to the home to justify all the information. So the open fields doctrine allowed them into the home in some ways, but because there wasn't enough there and they had to keep on going, the case ended up getting thrown out and had to suppress the evidence. But it just goes to show you that all of that goes to show you all the different avenues the federal government has to take, or not just federal government, the state government as well, has to take with justifying their actions in trying to seize property. Second item I want to discuss is consent searches. And I'm going to keep this relatively brief. Number one, everybody has a right to not consent, and everybody has a right to consent to a search. What do I mean by this? You can say no. You can say no. There's nothing wrong with that. And the officer, whichever officer it may be, cannot use the fact that you said no as the only reason for justifying a search. Now, notice I said only. That means that if it was a contributing factor, that is okay, but it better not be the only one that you had. So if you say no, please make sure you understand what it means and also understand that there may be other evidence that could potentially be used against them. It's a facts and circumstances analysis. It means it's going to change. Every time the facts change, the analysis is going to change. Now let's talk a little bit more about consent. Number one, the officers do not have to tell you that you have a right to say no. They do not have to do that. An officer can always come up and say, hey, can I search it? And if you say yes, well, I mean, unless you have a different argument like involuntariness, the consent's going to be good. So always know that you have a right to say no, but the officer doesn't have to tell you that you have that right. So it's going to come off a little bit. He or she may come off a little strong trying to get you to consent, but you can always say no. The second thing, consent has to be voluntary. It has to be knowing and voluntary. And what does that mean, knowing and voluntary? You have to know you have the right to say no, and that's kind of weird how officers don't have to tell you to say you have the right to say no, but you have to know that you have the right to say no. And believe it or not, it's a very subtle thing that happens. It's as easy as like, can I search your vehicle? And you say yes. You knew you could have said no. It very split in the hairs, very subtle, but that's enough to say you knowingly knew you had the right to say no. And then it has to be voluntary, means you can't be under coercion. That element's a little easier to attack, is the voluntariness. If you're a younger person and there's 6 officers and they're asking you if you would consent, that kind of comes off a little coerced in a way. If there are 5 of you and 1 officer, and the officer's like, hey, can I search your vehicle? Well, that goes to voluntariness, where you truly coerce when you think about the grand scheme of things. So it has to be voluntary and has to be knowingly. And the last thing is that it only has to be apparent that the person could give consent. What does that mean? 2 people living in the same home. Let's flip this from the stereotypical one you will usually hear. Boyfriend lives with girlfriend. Okay, girlfriend is being investigated for a crime. Girlfriend owns the house. Name's on the deed. Everything says girlfriend owns this house, and boyfriend doesn't even get mail directed there. Okay, girlfriend is upstairs asleep in her bedroom. Police come knocking on the door. Boyfriend opens the door. Hey, how's it going? Why are you here? Oh, you're here to investigate my girlfriend. You want to search? You want to search the house? You want to look around? Yeah, sure. Why not? Come on in and search. Boom. Officers have the right to now search, even though he does not own the house, even though he doesn't have mail directed there. He just lives there. Well, that's the thing, is he lives there. I don't care if he doesn't even have a key. He lives there, so he has some apparent authority. He has some apparent authority to let people in and out of the house. So that's all it takes, even if there's 2 people. Now, you might be wondering, well, what about kids? Well, kids are different. That's not apparent. It's not apparent to a reasonable officer, and that's the rule. If a reasonable officer could have known that this person did not have parent authority, then they can't let them in. So if a 13-year-old comes up in the door, the officer, any reasonable officer would know that that 13-year-old does not have a parent authority to let people in. But if it's, 50-year-old granny coming to the door, there's an issue of fact there. There's an issue of wondering whether or not she has a parent authority, and that would be something that would be litigated in a motion to suppress. So that would be in a suppression hearing. That would be the defense attorney's argument. 50-year-old granny did not have a parent authority. Officers should have known better. What is the government going to argue? 50-year-old granny did have a parent authority. Officers don't have a need to, they don't have to investigate the circumstances of whether or not she had authority. They just need to know whether or not that was an adult, someone who had knowledge of what the police do, why they would be coming to your house at a random time of the day. That would be the argument they would make. Who would win? Don't know. It's a toss-up, depends on who's the judge. But that's consent searches. Understand that. Oh, last couple things on consent. I'm sorry. If there are multiple people and only one gives the apparent authority, one has apparent authority and they consent, but as soon as the other person comes around, so like let's go back to my boyfriend-girlfriend model. If boyfriend gave consent and all of a sudden girlfriend wakes up and comes downstairs to see the cops are there, and she immediately says, I want you out of my house, you cannot search my house, the police officers have to pack up and leave right there and then. Consent has been revoked. That's the beauty of consent. Once it's been given, it can always be revoked. It can be modified as well. The scope of consent is based on the amount of consent given. Now, boyfriend said, come in and search my house. So even though it wasn't his house, but he still said, search my house. The police officers are going to take that as like, I can search every nook and cranny. But if boyfriend's like, yeah, sure, you can search the kitchen. Well, then that's all they're going to search. You get to walk your butt from the front door all the way to my kitchen. You get to search around in there, and then you get to walk your way back out. Now, of course, don't forget plain view. In between that walk, if they see something in plain view, they're legally allowed to be there because in order to get to the kitchen, they had to walk through the house, if that's how the layout of your house is. So anyways, that's consent. Last thing we're going to talk about is vehicle searches. And I don't want to go into a deep dive into this because not all of it's really relevant, but I want you to understand something. Probable cause is a big thing. Imagine the vehicle as a person. And we talked about before that you have to have probable cause to seize a person, to actually see. And now, if it's a Terry stop, you can do that as well. So let me backtrack that actually a little bit. Exactly. A car is like a person when it comes to applying the Fourth Amendment analysis. If you have reasonable suspicion to stop a car, you have reasonable suspicion to stop a person. If you have reasonable suspicion to stop a person, you have reasonable suspicion to stop a car. And we all know what a reasonable suspicion is. It's facts and circumstances. It's based on the totality, whether or not an officer has articulable reasonable suspicion to say whether or not crime is afoot. So if the car you believe has reasonable suspicion that crime is afoot, that car was involved in some sort of crime activity, getaway car, speeding, infraction, registration expired, that's reasonable suspicion. The registration being expired, reasonable suspicion. All right, so if you have reasonable suspicion to stop, you can stop. Same thing goes with probable cause. You can stop on probable cause alone as well. Even if, and let's talk about a car for a second. If you don't have reasonable suspicion or probable cause to stop the person, but you have reasonable suspicion or probable cause to stop the car because the car itself was involved in some sort of crime, that's enough. You don't have to forget the person. Stop the car, tell the person to get out, and be like, your car right now is under reasonable suspicion or under probable cause. The person is not. Now, depending on what you find in that car, you might have reasonable suspicion or probable cause actually to arrest the person, if that makes sense. So that's the basic layout. I'm not going to go into justification for why we have all these rules for the car, but I will say this. There are two very unique situations. I told you about the probable cause thing. As long as you have probable cause, you can always make the stop. Scope will be limited to probable cause. Scope will be limited to the reasonable suspicion. But now there's a very unique thing called search incident to arrest. What if you do have probable cause to arrest the person in the car, but you don't have probable cause for anything else in the car? Just the person. You stop the car, you arrest the person, but what about the car? The car is going to get searched no matter what. I will say that. Either at the beginning or the very end of this story, the car will be searched. But what if the police officer was in such a hurry? Like, I gotta know what's in the car. Gotta know what's in the car. There's this thing called the search incident to arrest. Literally, incident meaning immediately after, or occurring, or concurring. Incident meaning at the same time. I take the person out of the car. They're, DUI. We'll just mention that, DUI. I arrest them and I throw them in the backseat of my car. Okay. Well, according to the search incident to arrest, I have actually handcuffed myself as a police officer on what I can do. At that point in time, because they are no longer in the car and they're in the backseat of my car, I can only search the car for things that are relating, if I have reasonable suspicion to believe that evidence of the crime for which that person is arrested is going to be found in the car. That would be beer cans. Let's say if I arrest them at the door, but I don't move them anymore, I can then search the inside compartment for anything that they have arm's reach. So just imagine that's the back seat of the car, that's the glove compartment, it's underneath the seat, it's between the seats, it's everywhere. It's not limited to the crime, it's everywhere. So understand that, understand consent, understand plain view and open fields. I think you'll be fine on this chapter. I know I went a little bit longer. This is deep stuff. This is good stuff. This is stuff that's heavily tested in every situation you'll be in, and you'll see it again in your profession. Thank you for staying with me, and I'll see you for chapter 14.